All right. This is Beware Mouse. We're going to be taking a look at some. I'm going to let this roll in the background. I got all the copyrights on this one, folks.
This one's for you.
Yeah, this one's for you. This one's going to blow your minds, folks. I've been sitting here screaming about this, and everyone's been talking about, you know, they're starting to sit there and realize that they're not defending their rights. They're preventing a federal offense. What is that? Well, somewhere along the line, someone forgot we have laws. Earlier this month, Democratic Eric Swalwell introduced a bill to make it a federal crime to physically attack a journalist. As a member of the minority party, likely to note, the bill has little chance of passing, is more an exercise in virtue signaling than legislating. But all the bill demonstrates is two troubling trends: a lack of respect for the limits of federal power and the profound misunderstanding of rights protected by the First Amendment. Orwellian title of, for the first time, defines reporters as protected class with special privileges in the name of protecting reporters. The bill would degrade First Amendment freedoms for all Americans. How would it do it? Because how do we know you're entitled to these special privileges? Federally protected special privileges that nobody else has, whether you're following the First Amendment or not. That's a trick of the law. But is it already illegal for someone to go out and punch reporters? Why, yes it is. Specifically, who is it illegal for in order to go out? Does a person in the street have a right to punch anybody? No. Being a reporter, are you already specially protected under the law? Yes. It's called the First Amendment. Congress shall make no law respecting an establishment. Here, let's blow this up a little bit better for you. Of religion or prohibiting the free exercise. Prohibiting the free exercise. There is nothing they can make that will prohibit you from doing these things, or abridging, making it so it's difficult to do these things. Freedom of speech or of the press. The press is the only job title that has First Amendment protection, congressional protection, protection of the law being 241, 242, the U.S. Code, according to the Cornell Law School. We've covered this. If anybody conspire to threaten or oppress or abridge, abrogate, bypass, infringe on your rights, any right, it is a criminal act, and they shall be fined under this title or imprisoned. We do have a federal law that covers violation against and violence being used against a reporter on the job, with the intent to prevent or hinder their free exercise of being the press. Okay? And if those acts include kidnapping or an attempt to kidnap, actual sexual abuse, a strip search, attempt to commit aggravated sexual abuse, an anal probe, or an attempt to kill, they may be fined or imprisoned or even cost them their life. They may be sentenced to death. I think that's a powerful enough law to prevent someone from messing with somebody's rights. This one here says whoever, if regardless of what they're doing, whatever they're doing, under any color of law, statute, ordinance, poster 7, customarily, willfully subjects any person to the state. Okay, how? The deprivation of any right. They prevent anybody or interfere with anyone's right, even deprives them for a moment of exercising that free right, privilege, or immunity secured and protected by the Constitution, okay, including acts that would be reason of color, race, or a different punishment, shall be fined. Okay. What is wrong with these laws? Why can't we use them? It's very simple laws. All you have to do is go out and intimidate somebody. You don't have to punch somebody. All you have to do is verbally threaten them. All you have to do is stand in the way of the camera deliberately to prevent the person from doing their freedom of recording the events in front of them. Deliberately trying to prevent that as oppressing that right. They are prevented from standing around preventing you from recording the arrest. Aren't these satisfactory laws? This is from the Department of Justice. Seems like they know about these laws. If death results, you want to know something? 247. Okay. Let's see. Where was that? No person shall be prosecuted, tried, or punished for any non-capital offense under this section unless the indictment is found or the information instituted not later than 7 years after the date for which the offense was committed. Non-capital offense. So you have 7-year statute of limitation, not a 2-year as they pretend to, and that's for the criminal. After the criminal, after this here expires, I guess the 2-year civil should start by law. They don't practice this, but by law, that's what it should be. And if anyone wants to sit there and smoke weed for a medical reason or religious reason, who determines your religious belief? Do you determine your religious belief, or does the court? By presenting this question, it's all over, because whoever intentionally defaces, damages, or destroys any religious real property because of the race or any other reason, individual associated religious property, or attempts to do so by making a law for, shall be punished under this for this section. Okay, but what does that include? Intentionally obstructing by force or threat of force a police officer searching you for your marijuana, any person of enjoyment of that, and your pipe of free religious exercise belief under the fact that if it is a right, it cannot be neither granted nor licensed issued for. And if the Indians have the right in order to smoke weed, you do too for a religious. And how do you smoke that weed? Is it the exact same thing as the religions of the Indians? No. You believe it the same way and is entitled to smoke weed under your religious belief right here. And if anyone intentionally obstructs you or threatens you by force, they're guilty. And you have 7 years in order to bring them to justice, folks. It doesn't matter. They can even find you guilty of their law, but they are guilty in return. Both are guilty, not one. And you've established that with your criminal conviction, and the only thing you have to do is claim it. They're out, and that is the fact that you didn't claim a religious right. So claim your religious right under Section 247, and claim and ask the question, Who determines my religion? Does the court or do I? That's it. They can't go there. Shut up afterwards. You don't have to answer. That's your private belief. You are not starting a religion. You believe this way. It is your religious belief. You're not starting a religion. You don't have to. They cannot dictate that you must believe their version of Christianity mixed with Muslim or anything else. You have your right to believe. So when a police officer stops you under 18247, he is prevented from interfering with your religion. So therefore, you have to claim your religion up front. That is a legal technicality, but that is the only thing that they will ever be able to get a conviction, because you did not claim your right. And that's what they do. As soon as you walk into that courtroom, you turn over your rights to the court. How many ways do they have for you to do that? You have to declare that right first. The court then has that before them. The judge cannot argue or decide on anything that is not before them. So you have to claim that. I have a right, and who determines my religion? I do. End. This has been Beware Mouse, and may your God be with you.